So we will discuss today so-called Omnibus simplification package, and basically when so many unexpected things are happening because of the competitiveness compass, because of Draghi report, because of Omnibus simplification package, that every time when I am starting to talk about this, I feel like I'm rambling nonsense and sound delirious even to myself. But yeah, we will try to make this a little bit clear for all of us. And also our special attention will be about candidate countries, especially Ukraine. How does Omnibus impact candidate countries or not? And also another special focus will be on conflict-affected areas and high-risk areas. Should we expect that Omnibus will change something in corporate sustainability due diligence directive and sustainability framework related to these issues? We have today our speakers, and some of them, most of them are our mentors, mentors of our BHR for Ukraine Mentorship Program, and we are very thankful them for this role as well. So today with us, Irene Pietropaoli, Director of the Human Rights Due Diligence Forum, British Institute for International and Comparative Law, Anil Yilmaz, Senior Lecturer at Essex Law School and Human Rights Center, Siniša Milatović, Business and Human Rights Specialist, UNDP, and Robert Khorolskyy, Legal Counsel at American University, Kiev. And we will divide our discussion in two parts. First of all, Irene and Anil will provide us with general overview of corporate sustainability due diligence directive, and with Omnibus, a lot of things, as I already told you, are happening right now, and basically today is the last day when members of European Parliament can submit their amendments to the proposals about urgent consideration of Omnibus and all this super fast track to consider Omnibus in the European Parliament. So right now all these things are happening. And after that, we will have more free discussion with all of our speakers, and especially I will address my questions to Robert and Siniša to discuss Ukraine conflict-affected areas and what is happening around these issues. So, Anil, the floor is yours. Corporate Sustainability Due Diligence Directive.
Thank you, Olena. Thank you, Tamara, for organizing this and having us over. So I have about 10 minutes, so I'm gonna get going quickly. I wanted to talk a bit about how we got here, and then just a very brief overview of that, and then I'll talk a bit about what's in the original CSDDD, and then pass it on to Irene to talk about what the Omnibus is planning to change. So I call these laws corporate accountability laws. More generally, maybe that's not the best term, but we started seeing the emergence of corporate accountability laws about 10 years ago, although there are a few that predate that period. And they kind of can be categorized into two groups: transparency laws, two main groups, and then human rights due diligence laws. And we started with transparency laws, like the Modern Slavery Act in the UK, or the EU's non-financial reporting directive originally, now became the Corporate Sustainability Due Diligence, Corporate Sustainability Reporting Directive. And then we have human rights due diligence laws within EU primarily. We have the French law. There's a law in Germany. There is a law in Norway. And I'm sure most people here know about these laws. I'm mentioning them because I don't think we can discuss the CSDDD and the Omnibus without kind of taking note of these existing laws. So we have these different types of corporate accountability laws, and I think CSDDD is kind of the most comprehensive and most impressive one of them all, as it currently exists, although it's going to be probably changing a lot, and we'll talk about that. So if we look at what's in the Corporate Sustainability Due Diligence Directive, I think it's we can agree that it's the human rights and environmental due diligence law with the largest reach as it stands. It will be transposed into national laws of 27 member states, but its reach goes, I think, beyond member states, which we will also talk about, because it's going to impact both non-EU companies, certain non-EU companies operating within the EU, and I'll talk about that in a little bit. But it will also have this ripple effect of, you know, concerning all companies that are within the supply chain of European-based companies, because when EU companies have to, the largest ones especially, have to comply with the directive, they're going to have to engage with their suppliers, with their subsidiaries overseas, and so it will have this effect going beyond the member states. But I think even the fact that this will be law in 27 member states, or its format after the Omnibus changes potentially, is, I think, a real important fact to mark, but also, I think, incredible progress in the area of business and human rights, despite its limitations. So what this Corporate Sustainability Due Diligence Directive does is to require covered companies to carry out human rights due diligence and environmental due diligence, and also prepare a transition plan, adopt and implement a transition plan for climate change mitigation. So that's different than the other human rights due diligence laws that we have in force, that transition plan. Currently, in its current form, it covers large companies with more than 1,000 employees and worldwide annual turnover of 140 million euros. And this was meant to be over time staggered and widened the scope. It also applies to companies generating the same amount of turnover in the EU, but are of non-EU origin. So those are the companies that will be covered in the initial phase. What does human rights and environmental due diligence capture? It is expected that companies will carry out human rights and environmental due diligence covering their own operations, their subsidiaries, and chains of activities. And this concept of chain of activities is something that I'm sure Irene will talk about, because that is changing in the Omnibus. With chains of activities, the EU, the CSDDD is covering basically the entire value chain of a company, including its upstream and downstream, although there are limitations on how far companies are expected to carry out due diligence when it comes to their downstream supply chain. And I'll be happy to explain the difference between the different the streams if anybody would like me to do that. So please let me know either in chat or raise your hand. So what is expected is that the company will carry out a risk assessment, integrate human rights and environmental due diligence into their policies and risk management systems, meaning that they need to identify and assess actual and potential adverse impacts. They need to prioritize impacts where necessary, so they have that option. They don't need to necessarily do everything all at once. They can prioritize and take measures to prevent and mitigate potential impacts and end or minimize actual impacts. Human rights and environmental due diligence under the current draft, not the omnibus proposals, has to be done on an ongoing basis. And that companies should take appropriate measures to address their, the human rights due diligence, whatever human rights due diligence processes come up with. They need to take appropriate measures to identify, to mitigate, and to prevent impacts, and provide remediation for harms suffered from actual impacts. In all key stages of the human rights and environmental due diligence process, the directive requires companies to engage in meaningful stakeholder engagement, meaning that in identifying impacts, in developing risk management systems, in developing action plans, they need to engage with, meaningfully engage with stakeholders within their supply chain, within their business operations. Businesses also have to establish and maintain a notification and complaints mechanism, so that if impacted individuals or groups within their chain of activities have grievances, they can, seek remediation from that internal process or notify issues. And companies are required to monitor the effectiveness of their due diligence procedures. So they can't just develop something and then leave it there. I mean, it does have to happen anyway on an ongoing basis and be, compliant with the requirement of taking appropriate measures. But there's also this requirement to regularly monitor the effectiveness of their due diligence processes and outcomes. And then there's the requirement to publicly communicate on their human rights and environmental due diligence processes and outcomes. Key impacts have to be reported, and this is connected with the Corporate Sustainability Reporting Directive. Companies that are already reporting under that directive will have to continue reporting under that, and companies who are covered by the CSDDD but not covered by the reporting directive will have to report additionally to that. In order to monitor compliance, companies' compliance with directives, provisions, and requirements, the directive requires member states to establish a national supervisory authority. We have something like this with the German law. The German Supply Chain Due Diligence Act has established a monitoring body, an enforcement body. Similarly, the Norwegian Transparency Act has one. So something similar has to be established by every member state that's implementing the directive. And this body will have the power to receive complaints, to ensure compliance with the provisions of the directive, and where necessary, they can issue injunctions or fines against companies for failing to follow the requirements of the law. Another really important provision in the directive is that it provides for civil liability in its current format, that it requires that all member states introduce provision for specific provisions for allowing that rights holders have recourse before national courts to seek compensation, reparations for companies failing to uphold their obligations under the directive's provisions. And when that results in harm for rights holders, they are able to seek remedies from national courts. Now, again, this is changing in the new, and there were quite progressive provisions around civil liability, especially in terms of legal aid provision, the possibility of NGOs or other civil society actors being able to take claims on behalf of rights holders who may not be able to do it on their own. There was also an easing of evidentiary burdens in the CSDDD at the moment. But all of these are being watered down in the Omnibus. I'm going to actually stop there and pass it on to Irene. I'll be happy to answer any questions. Thank you.
Yeah, thank you. Thank you very much, Anil. Just one question. I think that in terms what Irene will talk about, it's also important to know the process and the timeline of adoption of corporate sustainability due diligence directive. How long it took and what kind of procedures were involved. And then we will have a chance to compare what is happening with Omnibus.
So it's been a long process, a difficult political compromise already, I would say. I think it started in early 2020, the entire process, and there's been, you know, different drafts by different parts of the EU. The Commission had a draft, the Parliament was more progressive. So it did take, this was already the compromise, this version of the directive, and it was passed as EU law. So what we're seeing now with the Omnibus is that we're reopening. I think many people, I didn't know that this was even possible, that you could amend past EU law in this way. And I'm embarrassed to say that, but I used to teach EU law at Essex for a period, not my area of expertise, but I didn't know that this was possible in EU legislative process. And when we were at the UN forum in November, everybody was kind of talking about what this omnibus is all about, because no one had heard of it before. But I'm sure an EU law expert would know all of this. But most business and human rights experts, I don't think, knew that this was even possible. It was such a victory, even though it's got shortcomings, right? That it is, you know, a shock to see that this can be reopened and watered down in the way that it is being proposed.
Yeah, thank you. Thank you very much for this comment. And Irene, please, so what is happening now?
Yeah, what is happening now? Thanks, Olena, for inviting me, and Anil for the excellent overview, which leads very well to my points on the changes introduced or the changes that Omnibus should would like to introduce. So, okay. Sharing, okay, sorry, just the few awkward seconds until the presentation is actually shared. Just to also let you know that so I'm a senior fellow at the British Institute International Comparative Law, and we were involved since the beginning, let's say, of this process, because the European Commission in 2018 commissioned BIICL a study on human rights due diligence in supply chain that then was published and was sort of the basis of the European Commission proposal that, as Anil said, was then released in 2020. After a long, prolonged and complex trilogue negotiation between the Council and the Parliament, and they released the CSDDD, I also did not know that it was possible to change law after it was adopted by the three bodies of the European Union. And it's very unfortunate because it's really having a law and then changing it before it even enter into force. So it's really create this uncertainty and this lack of clarity that we actually heard over and over again that people need, and business actually need. We carry out constantly, for our research project, interviews with business, and they all always say that they're actually in favor of regulation that clarify what the actual requirements are. So on that basis, what does happen is that in February, the European Commission released this package of simplification of Omnibus 1 and 2 proposal. So the simplification thing is actually is important because they sort of justify with the aim of simplifying the corporate sustainability reporting. In reality, as we will see, especially in some of the articles and the way they are drafted, really is difficult to really see this simplification as is creating even more uncertainty in exactly what the plausible risk is, and but we will see now in a moment. In terms of next step, also important to remind that right now Omnibus has not passed yet, so it is currently a proposal. So currently the CSDDD still applies. That means that there is a timeline of like 2 years for the European for the EU member states to actually pass into national law, which has started and at the moment is still current. So we know that there are like some countries, for example, in the Netherlands and some of the Scandinavian countries that are actually working based on this timeline, because it's not sure exactly yet what is happening with Omnibus. So in terms of next step, again, the European Council and the Parliament will have to agree on the text and adopt the new text. Also to clarify that changes with Omnibus are not going to affect only CSDDD, but they're going to affect all the corporate sustainability reporting regulation. So they will impact, in addition to CSDDD, also the corporate sustainability reporting directory, CSRD, the taxonomy regulation, and also the carbon border adjustment mechanism. So today we are only going to look at the CSDDD and only look at like a selection of changes. Some of the main changes are the timeline, which is postponed by an additional year. And so in terms of the transposition, meaning the time that member states have to turn into national law, is moved to July 2027, meaning that then the first year of application will be 2028. The scope is again limited, considering also the CSDDD was already, as Anil says, so it's already an agreement that had already over the year limited the scope of companies. Now it's limited to also the information that large company can request from SME, which is a very strange, article actually. So basically, companies cannot ask information in the supply chain to SME. They have less than 500 workers, 500 employees, which is strange, as you know, you would have this situation where maybe like an organization with like 400 people will not have to give information. So it's also how it works in practice will create, I think, additional problem. But anyway, there is also a reduction of the frequency of assessment from annual to every 5 years. Other aspect of the due diligence requirement, for example, as we now will see in some details, the assessment only with tier 1 suppliers. Also very unfortunate is the removal of the alignment of the climate transition plan requirement in line with the CSRD. And even more problematic is the removal of the civil liability. So it's not actually completely removed, but it's now left for national countries to decide. So it is not part of the harmonization condition. So this is probably one of the. This was going to be one of the main added value, right, of having like a law that also create a liability. So if that's not it may not be there in national laws anymore. So looking at the selection of a few articles, so there are like changes in like quite a few articles, but I just selected some of the one that probably are the most interesting for this webinar. So one is the scope of the due diligence. So in Article 8.2. So the current test of the CSDDD is that companies are required to conduct due diligence on human rights across their entire chain of activities, including direct and indirect business partners. That was quite comprehensive definition in line with the UNGP, including upstream and downstream, with some few gaps that were identified in the entire value chain, but overall, really, it was the entire value chain of the company. Now, the due diligence, so with the proposed text in Omnibus, the due diligence obligation is limited to direct business partners, so it's tier 1 only. Here, and that is also the complication, is that companies are required to conduct an in-depth assessment behind tier 1 only if they have a plausible information of adverse impact by indirect business partners. So in this sense, the proposed text of Omnibus is quite similar to the one of the German Supply Chain Act. The German Supply Chain Act also is only for the due diligence assessment only limits to tier 1, except when there is sustained knowledge of a risk. So this, as we have seen also in studies that BIICL carried out, creates a number of problems, both in terms of the actual prevented risk assessment spirit of the UNGP, which is not respected anymore, but also even for companies, because plausible information of adverse impact beyond tier 1, so from tier 2, right? In reality, we can say that every large multinational company, because CSDDD only covers very large multinational, very large companies. Right? So every multinational company will have plausible information of adverse risk in reality. It's almost impossible to say that there is no plausible risk of human rights impact beyond tier 1. So then what does it mean? Company will still have to do it or not? So it just creates like an unnecessary complication that risks to turn this into like the typical questionnaire tick box exercising that we wanted to avoid. So the other article that I think is relevant here is the termination of business relationship in Article 10 and 11. So the previous, let's say, like CSDDD, the current text of the CSDDD is that the termination should occur as a last resort and in a responsible manner as per the UNGP and the OECD guideline, only where there is no a responsible expectation that efforts outlined in the company action plan with clear timeline will succeed. So there is the idea that the company are encouraged to engage with business partners, to use their leverage to find a solution. The CSDDD does mention cases where leverage is not possible, for example, in the case of state-imposed forced labor. In that case, the company just required to automatically terminate the business relationship, but except those few cases, the idea is that there should be this engagement. In the proposed test, there is no timeline required for implementing this action plan. And as long as there is a reasonable expectation that this plan will succeed, company cannot be held liable. And also the requirement of considering the business relationship, so the termination of the business relationship as a last resort is no longer included, which again, it creates it create a disalignment, disalignment with the spirit of the UNGP. On the civil liability for damages, which in the CSDDD company had civil liability for damages for failure to comply, and the right to full compensation for damages for the affected people. Now this provision is removed and is left to the discretion of member states. So they can include it, but they are not required to. So this is one area that, for example, there's a lot, and there is going to be a lot of work from civil society to try for member state to actually opt for civil liability, but not having this requirement may create again a difference between different jurisdiction, and like another problem for company that operate across different jurisdiction. Even in the EU, some country may have a civil liability, some country may not, for the exact same type of requirement. So I'll stop the presentation here. I only want to say, though, that despite some of this negative aspect, the scope of the human rights due diligence really still there. Actually what the human rights due diligence means, and the risk-based approach and the preventive approach is still there. So that's actually is important, because company will still be required to conduct that diligence. Yes, thank you very much.
Thank you very much, Irene. And probably just one question to you, just to explain to our participants who probably don't follow so deeply and carefully to the current process. When we can expect the final decision about Omnibus, and is there still a chance that it will not happen?
So I don't know. I'm not sure, to be honest. When I don't know if others in the can.
I might know something.
Yeah, please,
Yes.
Siniša, please.
I mean, this is off the record. Not that I know it for certain, but there's talk of the trialogue resuming in October this year. So
and then like how long it will we will just.
I don't know. I mean, I assume it'll be some sort of fast track procedure, so I'm not really sure.
Yeah, there should be that thing that there is like a fast track procedure, because clearly it cannot take another 4 years, because otherwise it will be after the CSDDD was already. So it should be a fast track, but then how fast this fast track is not clear, and also what the position of the council and the parliament also is not clear yet.
Yeah. So basically, I to be honest, I'm following Andreas Rasche, right, in LinkedIn.
Yeah.
For our participants here, I probably could recommend to follow him, because he is sharing a lot of insights. So he is associate dean at Copenhagen Business School, and he shared yesterday, I think, that we could expect the final decision by European Parliament before the summer, and the final legal text, can be adopted before the summer. But again, it's just his opinion. We'll see. Yeah. Anyway, Very, very interesting developments. And also one more question to all of our speakers, if you know, if you have also some insights about this. It was mentioned that Germany and France, they have due diligence, mandatory human rights due diligence laws. And I heard from some experts that in case of France, if corporate sustainability due diligence directive will be in the edition that Omnibus suggests, it will be more weaker than the current version of the French regulation. So what should, no, it's interesting question. What should member states do in this case if on the European level the regulation is not so strict as the current regulation in this member state?
I would just say okay, this is maybe wishful thinking, but the directive is the floor and not the ceiling. So member states can still have, stronger or stricter provisions. Sorry.
Isn't there, sorry, Anil, sorry to jump in,
No,
but
that's
isn't
fine.
there a provision in the Omnibus, or at least in the sort of explanatory paragraphs of the Omnibus, that the directive will be the ceiling?
Is there? I did not actually see that.
I think there is. I mean, I
But
think
EU directives are not supposed to be
I understand.
ceilings. That's okay.
But
I think for what I understand is that there are certain things that are open to harmonization and certain that are not, right? I mean, like, so let's say for some is the floor, for some in the city, maybe, but because I wouldn't imagine the French, for example, why the French due diligence law will be more comprehensive, because it includes the entire supply chain, for example, the entire value chain, and includes civil liability. Now, civil liability, we know for sure that it's possible for Omnibus right now for countries to include that. For example, for tier 1 only, I don't know if that means the country cannot go beyond tier 1. I don't know. I would imagine that if they already have a law in place, they don't have to amend it to make it like weaker, right? But
I guess we'll see.
Yeah, but definitely there is an issue there because, again, I need to check specifically, but if I remember correctly, Corporate Sustainability Due Diligence Directive has this special provision that countries could have most regulation which would be more strict than directive. But again, if I understood correctly, the omnibus proposals, this kind of provision is not there. So there is a question, could countries go with more strict regulation or not? No, sorry. Yeah, so interesting. Because my understanding was the same as Siniša to us. And yeah.
Of the omnibus states, without prejudice, now we have to get into real sort of detail, but I mean, I think the devil's in the detail. That without prejudice to Article 1, paragraphs 2 and 3, member states shall not introduce in their national law provisions within the field covered by this directive, laying down human rights and environmental due diligence obligations diverging from those laid down in Articles 6 and 8, Articles 10, paragraphs 1 to 5, Article 11, paragraphs 1 to 6, and Article 14. Notwithstanding paragraph 1, this directive shall not preclude member states from introducing in their national law more stringent provisions diverging from those laid down in provisions other than Article 6, 8, Article 10, 11, and 14, or provisions that are more specific in terms of the objective or the field covered, including by regulating specific products, services, or situations in order to achieve a different level of protection of human employment and social rights, the environment, or the climate. So there's clearly some sort of we haven't gone into great detail, but there's clearly some sort of being set on certain provisions, which is quite worrying.
Yeah.
And sorry, and that ceiling is below the standard created by the UNGPs. So that's additionally worrying in that, they're setting a ceiling which doesn't meet the UNGPs even. Never mind advancing from the UNGPs. It doesn't even meet the UNGPs.
Yes, thank you very much for these details, and also I shared in the chat the link to the podcast with Claire Bright, Heidi Hautala, and Richard Gardner, because I found it very interesting, and they shared their reflections about Omnibus, and also Richard shared very interesting reflections about when the financial crisis occurred. European Commission also was forced to adopt some regulation in very fast track, but even in those moments, the European Commission followed to the procedure and was very open for communication with different stakeholders and conducted different discussions, which it seems is not happening now, at least at those levels that we could expect. So there are many concerns about that these suggestions are not in line with UN guiding principles, and the process is not in line with our rule of law expectations. Siniša is already part of the discussion, and I should say that we were thinking about that we would need 3 more people, someone who would represent another candidate countries, not just Ukraine, someone who could talk about business and conflict, and someone who can share global perspective on corporate sustainability due diligence impact. But then we realized that we just need to invite Siniša. So Siniša, please, my question to you. Actually, do we have provisions about conflict-affected areas in the directive? How these provisions, because I know that they are there, how these provisions were included into the directive? It's also about the process, the very long process, and the chance to jump into this process for different stakeholders. And what can we expect related to these provisions in the future because of the Omnibus?
Okay, thanks for the kind introduction and the excellent question or questions. So in terms of provisions on conflict-affected areas in the CS3D, yes, there are. They're in a very sort of roundabout way. So bear with me while I try to explain, and it relates to the process. So for a long time in the draft text of the directive, there was explicit provisions in the operative text of the directive on conflict-affected areas. And they basically stipulated that businesses have a duty to carry out so-called heightened human rights due diligence, and I'll explain a bit what that is later, in conflict-affected areas. So essentially what it meant was that businesses have an additional duty, an additional responsibility in conflict-affected areas, not just to be sort of to assess and address their impacts on human rights, but also to assess and address their impacts on the conflict itself. So how are they impacting conflict dynamics and so on. Now, there was opposition, as far as we know, from some member states and some stakeholders, and eventually things got shuffled around, provisions, and what we ended up with was a kind of a halfway solution, which is better than nothing. And what it basically says is, it says in the recital, so the introductory part of the directive, and bear with me, I'll try and sort of read this to explain what it means. So what it says is, in conflict-affected and high-risk areas, which is a term used in EU law generally, human rights abuses are more likely to occur and to be severe. Companies should take this into account when integrating due diligence into their policies and risk management systems, et cetera, to ensure that codes of conduct and processes put in place to carry out due diligence are adapted to conflict-affected and high-risk areas. Companies should take into account that such situations constitute particular geographic and contextual risk factors when performing in-depth assessments as part of the identification and assessment process, when taking appropriate measures to prevent, mitigate, bring to an end, and minimize identified adverse impacts, and when engaging with stakeholders. So clearly there's an emphasis on taking into account where you are, the context. For this purpose, companies may rely on the Commission's guidance which doesn't exist yet, which should be developed. So the European Commission has to develop a guidance on the assessment of risk factors associated with conflict-affected and high-risk areas, which should take into account the UNDP's guidance on heightened human rights due diligence. So that's, I come from UNDP, so that's a guidance that we developed with the UN Working Group about 3 years ago. So what does this all mean? Essentially, what it means is that if you look at an operative article in the directive, Article 3, it basically says that, you know, companies have to take into account risk factors. Those risk factors include geographic and contextual risk factors. So just by virtue of where you're operating, that's a risk factor. And then in accordance with that, you as a company are supposed to carry out your, you know, other obligations. So essentially from Article 8, 9, 10, 11 of the directive, which is mapping your own operations, so human rights impact assessments and so on, prioritizing your impacts, bringing these impacts to an end, engaging with stakeholders. All of this should be done if this directive is read as I suggested. All of this should be done to take into account the fact that your company is operational in a conflict-affected area. So just to give you an example, what does this all mean? Well, for instance, if you're, as I said, if you're assessing your impact, it shouldn't just be on human rights, but it should be on a conflict. So, you know, you could be a company that's perpetuating conflict. You could be having recruitment practices that are seen by certain communities as discriminatory, even if they're not. You could have, you know, stakeholder engagement has to be a bit different, because who are your stakeholders in a conflict? It's not just your workers or the communities. It's actually a bit broader than that. You know, it could be local paramilitary groups, armed groups. It could be political parties. It could be a variety of others. I mean, I'll be happy to explain what this all means in more detail, but all of this just to say that the CS3D itself does have provisions, that it does take into account the fact that conflict-affected areas are specific. Obviously, Ukraine is a conflict-affected area by any definition. I mean, the question becomes more, what about certain other areas where, you know, there isn't as much of a full-out war, but in Ukraine, that is definitely the case. So when it comes to Ukraine itself, it is a conflict-affected area for the purposes of the CS3D. Okay, back to you, Olena.
Yeah, thank you. Thank you very much. And I shared the guide that UNDP prepared with the UN Working Group and Siniša mentioned, and this guide is mentioned in the directive. So if you haven't read yet, please do this, very useful thing. Siniša, please stay with us for the next part, because I want to ask Robert, but also I want to ask you about Corporate Sustainability Due Diligence Directive and its impact on candidate countries. Robert Khorolskyy represents Ukraine here, and me as well, and Siniša, I think, could talk a little bit about Serbia. For me, it's also very interesting processes because of many reasons. But first of all, Ukraine is the first country which received questions from the European Commission within EU negotiation process about business and human rights, but specifically also about Corporate Sustainability Reporting Directive and Corporate Sustainability Due Diligence Directive. And basically, Ukrainian government was asked how Ukraine is going to implement this regulation, what is happening in Ukraine related to this regulation, and Ukrainian government seems to be very serious about these questions, and all these negotiations are happening now. The chapter 20, which includes some of these questions, will be discussed in the end of this month, on 29th of April, I think. So first of all, when we developed another report also with UNDP, the regional study on implementation of UN guiding principles in Eastern Europe, Western Balkans, and Central Asia. Irene Letnar-Chernic, Beata Ferracek, and myself, we prepared this report, and one of the conclusion was that EU developments on mandatory human rights due diligence is very important driver of changes in the region, and governments in the region, they basically take these developments in a serious way. It was one of the conclusion, and another conclusion was that for the region, it's very common situation when we take competitiveness and business-friendly regulation as a priority, because we are trying to attract investments and so on and so forth. And that's why we somehow prioritize competitiveness and business-friendly environment over sustainability and human rights. And now it's very, confusing thing to see the same developments in the European Union, and it's a big concern for candidate countries and for entire region, what impact it will have for the region. So my question goes to Robert and to Siniša and to all participants. What do you think about the current developments and their potential impact on the region and Ukraine in particular?
Thank you for giving me the floor. Well, the question is not easy to answer, frankly saying, and to give some answers, I think the first stage is to structure information, because this regulation is a very complicated thing, which changes many huge amount areas of business life, of human rights protection, and many consequences we even cannot predict at the moment. What will be the consequences? If we are talking about Ukraine, I can clearly see, as everybody, that there are two impacts of this directive. The first and immediate effect, it's about its own companies, which will be covered directly by this directive, because they are covered by its scope. I haven't seen any assessments. Maybe you have such information. How many Ukrainian companies will be directly covered by this directive? But by the way, it's an interesting question whether there is such an assessment or research how non-EU countries how many non-EU countries yes, there is a general figure in explanations to Omnibus, but I would like to see split on the countries, for example, Ukraine, United States, and so on. Okay, thank you for information. So there will be few Ukrainian companies which will be directly covered by this, maybe tech and some other huge companies. And there is another group of companies which will be in Tier 1, yes, which will be covered by supply chain. And from this perspective, they are in the same conditions as any other companies in non-EU countries. Nothing special. And surely they benefit from both additional 1 year and from simplification of requirements, yes? Some simplification and minimizing requirements. The other, and from this perspective, the message from Omnibus 1 and Omnibus 2 is that this directive is a serious thing. Nothing will be reversed. So, frankly, it's a natural for European integration to move by such waves. Yes, strong requirements, slow integration, some easing in requirements. It's okay for European integration, we know this. But the political message is that this regulation is a very serious thing and it will survive, but it will be implemented in more long historical terms. However, I put footnote that Omnibus 1 and Omnibus 2, it's response to events before Trump era. And we don't know what will happen because as far as I understand, Trump is quite serious about changing many foundations of modern world, yes, especially business world, economic world. Anyway, I'm sure that human rights will be in the foundations of this architecture. The other question is which instruments will be used. We don't know the answers. Nevertheless, from current perspective, directive was confirmed, and it will be obligatory for any serious business, whether in Ukraine or any other country. So the message is take it serious. Sorry. Another aspect, influence on Ukraine is surely accession process, yes, and there is also nothing has changed from Omnibus 1 and Omnibus 2. Surely the requirements for Ukraine have minimized a little bit, but in overall process, since we are in the very beginning, nothing has changed. In this from accession perspective, I would like to emphasize once more that Ukrainian legislative requirements about accession process is in a very poor condition. Basically, the main source of our information about how EU accession negotiations are going is political statements of our politicians. And as you know, it's not a reliable source of information in any country, including Ukraine. And me as an expert, as a scholar, I would like to see some documents which say how Ukraine should conduct negotiations, how Ukraine should approximate its legislation, and so on. At the moment, as far as I understand, this directive is not mentioned in Ukrainian legislation at all. So it does not exist in Ukrainian legal field, in action plans and so on. Surely this task will be done, I'm sure, by the end of this year. But nevertheless, I would like to see how Ukrainian government is going to establish, for example, transitionary periods in the process of accession negotiations, because I don't have any idea how Ukraine will approach this very important issue, because nobody knows when Ukraine will become a EU member and whether at all will become. Now we hear 2030, but from people who will not be in power in 2030, yes. So it's easy to give some promises. And it's quite important for Ukrainian businesses which are not directly covered by this directive to know what to expect from prospective prospective Ukrainian legislation, which will appear as a result of EU negotiations. Yes. So gold plating, taking higher standard in EU member states, there is such a term, slang term, gold plating. Yes, it has been always a problem for European countries, and it's much bigger challenge for Ukraine, because the first question is, why should we accept additional burden if nobody knows whether Ukraine will ever become an EU member? My answer is that in case of this directive, it is extremely important to adopt Ukrainian law as soon as possible, because we are talking about market access. And anyway, independently of whether Ukraine will become EU member, how our negotiations will be fast or slow, anyway, this law must be adopted, this infrastructure must be introduced, because it is about real business, and I'm sure that in some years everybody in Ukraine business will understand this. So and the last point, I think that at this moment, taking into account our mentality, probably Ukraine facility instrument may become as an influence point, because it is directly connected with money, and from Ukrainian government perspective, real money always matters much more than some future ideals, something like Ukraine membership. Yes. So and there are some provisions in regulation on Ukraine facility which permit civil society to raise concerns about importance of implementation of this directive. So that's all. Thank you.
Thank you very much. And again, I shared some information in the chat. If you are in LinkedIn, we collected interesting information about our past events, in particular. Siniša also participated in the conference in Wageningen on 18th of February, together with the European Commission representative Alexandra Kuksova, together with Heidi Hautala, Nadia Bernas, and we discussed basically Omnibus and Ukraine and Serbia, and what should be next steps for candidate countries. And also I shared key takeaways from those conference and from the event that we conducted in Kiev on 6th of March, also to discuss corporate sustainability framework and candidate countries. And Robert participated. Thank you for this. And yes, Siniša, could you elaborate a little bit what is the current situation with candidacy status of Serbia? And,
I mean, I can tell you briefly about that, but then I also just wanted to say something about Ukraine as well.
yeah, please.
So briefly about Serbia, I mean, Serbia is an EU candidate country, formally. I think that there is some sort of renewed push by the European Commission to make sure that Serbia joins the EU despite what Serbia is doing. That's just my impression. This is between us. And, you know, we now have huge protests going on against the government and so on. So it's a very sort of tense situation, and EU membership plays into that. And partly because of business and human rights issues, because one of the key issues in the country is huge deposits of lithium in the west of Serbia, which European companies want to get their hands on, which the government is more than happy to give away, and which the people are very sort of divided, or rather against, actually, according to opinion polls, against any sort of exploitation of these resources. So all that being said, it's unclear where, you know, sort of the candidacy status is. I mean, 17 chapters of the acquis have been opened, 2 or 3 have been closed, but progress has been stalled for a long time. And there's political issues around that as well, namely the status of Kosovo, does it belong to Serbia or not, etc., etc. So there's a lot of issues there. So the impact of the CSDDD, I would say, nominally, Robert already mentioned a lot of sort of relevant points, which is harmonization with it. I want to mention one other thing, which is specifically currently relevant for Ukraine. Irene, I think, and Anil mentioned both, you know, this, that the Omnibus might change or proposes to change the scope of the directive when it comes to this chain of activities, that it will apply only to first-tier suppliers. But it should be said that in the Omnibus proposal itself, it does say that the proposal recognizes there can be situations where companies have to look beyond their direct business partner, namely where they have plausible information that suggests an adverse impact at the level of an indirect business partner. And then it goes on to say that where the companies receive the complaint or is aware of a credible NGO or media reports about harmful activities at the level of an indirect supplier, or past incidents involving the supplier, or where the company through its business contacts knows about problems at a certain location, such as a conflict area. So in these cases, essentially what it's saying is that actually, even according to the Omnibus, the duties of the companies under the scope of the directive will not be limited to the first-tier supplier. I think if you're a European company under the scope, you can't exactly pretend you don't know what's going on in Ukraine. I mean, I don't know. You'd have to prove that you're living under a rock or something. So that being said, I think currently, even under the Omnibus, even if it's adopted, you know, etc., I think the companies under the scope will have a duty to look further than their first-tier supplier when it comes to Ukrainian companies that are in their chains of activities, so-called chains of activities. So I would say that the application, you know, well, I mean, hopefully Ukraine doesn't stay a conflict-affected area too long, but I don't know what that means. I mean, there's also post-conflict, and even if there is a ceasefire, the terms of ceasefire and so on, it depends. All that being said, I think Ukrainian companies and the Ukrainian government would be wise, and same goes for the Serbian government and other candidate countries, especially to harmonize, because, I mean, obviously it affords a great deal of protection to their workers and communities, but even beyond that, not to think that, you know, European companies under the scope will somehow be able to wash their hands off what goes, you know, in their supply chains or in their chains of activities in Ukraine, in Serbia, and elsewhere. So I think it's sort of, you know, incumbent upon these companies to look. And I would also imagine that a lot of companies in Ukraine either are first-tier suppliers to European companies or want to become first-tier suppliers. I mean, why not? You know, there's no reason to sort of limit yourself. So, you know, if you want to expand your business, if you're a company and you want to, I mean, that's kind of a sales pitch to companies. You know, if you want to expand your business and you want to look forward, your competitive advantage will be if you already have these processes in place rather than lagging behind, having to introduce them, having to prove that you have them in place, and so on. I mean, I'm a human rights lawyer. I don't really care from that perspective. I care about human rights, but that is an argument that, obviously is relevant. And we see now with the Omnibus, actually, the limits of, the human rights sort of goodwill and the lack of a business case, how it's hurt. The idea that competitiveness as defined by Mario Draghi is essentially all it is sort of a race to the bottom line, clearly means that the business case for human rights has not been proven sufficiently or hasn't been convincing enough to policymakers in Brussels and elsewhere, despite the fact that lots of companies have lobbied for it, but clearly there was pushback from other companies. So I should say that business case matters. And ultimately, I think, it would be sort of prudent for companies in Ukraine, Serbia, elsewhere, to sort of get on board so that they can be well positioned to, do business with European companies under the scope of the directive. Thanks.
Yes, thank you. Thank you very much for this, Siniša. And also I should say about probably good practices from Serbia, and already that Serbian companies already felt the impact of EU member state human rights due diligence regulations, because when we discussed with Serbian companies and Serbian NGOs and state authorities what is happening, all of them told me that German supply chains act impacted Serbian companies significantly. At least they know now about this regulation, and they are trying to be in line with this regulation. And of course, for me, it's also the question of how European companies conduct and what is their strategy to communicate these issues with their suppliers in non-EU countries. And also between us, I had a conversation something around 10 days ago with one a very big European company, and they are going to invest to Ukraine, and they already have some potential suppliers. And first, what they are going to do is basically conduct heightened human rights due diligence in Ukraine, and provide their local suppliers with the basic understanding of what human rights risks are and what they can do with this. And my question to them was, are you going to provide these local suppliers with some additional support, or you just want to tell them that they need to conduct heightened human rights due diligence? This particular company responded that they are always about supporting their local suppliers in this regard, but we'll see. So it just confirms that despite of all this, turbulence around the corporate sustainability due diligence, and not just around corporate sustainability due diligence, but we can see the very strong general trend, unfortunately, in the EU as well, about how to simplify regulation and how to make it more friendly for businesses and so on. But still, we see that many companies are very much in line with UN guiding principles, with OECD standards, and let's hope that they will continue this efforts to implement these standards in reality. Do we have some other reflections, thoughts, questions? If not, I would like to thank to all our speakers and to all participants, especially to those of you who asked questions in the chat. And we are going to meet Tamara, please share information when will be our next meeting.
Our next webinar will happen on 9 April, and it will cover the due diligence as a private law concept. Extremely interesting topic. We already thinking about the questions and yes, discussing with our speakers. So it will be a very important contribution to development the concept. And then we will have 2 more in the middle of April. Please follow us and listen to all the webinars which we will advertise more soon.
Yeah, so not just to remind you that one of this webinar will be about gender equality issue, and in particular how the war changed the gender balance in the employment market in particular, but not just about this. And also Anna Tsuvina will share with us. She conducted the study based on corporate human rights, gender benchmark that was developed by World Benchmark Alliance. She conducted study for Ukrainian companies, so I'm also wondering about the results of this study. And another one will be about platform workers, also very topical issue. And yeah, about the next one, it should be very interesting from both perspectives, theoretical and practical, because from theoretical perspective, it will be about the concept of due diligence, because the concept of due diligence came from public law. No, I don't know if it came from public law, but it is used in public law, and in particular related to state obligations. And now we use it as a human rights due diligence. But of course, private sector's understanding of this concept is very different than human rights due diligence. So we will. Hopefully, we will talk a lot about, this development of the concept and how this concept now is used for human rights due diligence and so on. But also, we will discuss some practical issues about human rights due diligence and human rights impact assessment. What is the difference? Should we use another terminologies for being more clear and precise? So I hope to see you there as well. So thank you very much and have a nice evening.